Good evening, everyone. So, in this video, we are going to discuss two significant Supreme Court judgments of 2025 that are highly relevant from examination point of view. So, the first judgment deals with the interpretation of sentencing under the IPC and POCSO Act, especially in sensitive cases involving minors, clarifying how courts handle overlapping provisions. And the second judgment focuses on digital rights, linking access to technology with the constitutional right to life and liberty, and its broader impact on policy making for the disabled and marginalized. So let's see the first case. So a major Supreme Court judgment in 2025 clarified how IPC and POCSO work together in sensitive cases of child abuse. So the case name was Gyanendra Singh versus State of UP. And let's see the background. So the case involved a man convicted of raping his 9-year-old daughter, and he was sentenced under both IPC and POCSO. So he was sentenced under IPC sections 376 2 clause F and 376 2 clause I for aggravated rape, and POCSO sections 3 and 4 that are penetrative sexual assault. So, if a man commits rape or sexual assault on a child, he may be charged under both Section 376 of the IPC and POCSO under sections 3 and 4. Now, let's see how the court decides. So, under section 42 of the POCSO Act, when an offense is punishable under both IPC and POCSO, the law providing the greater punishment prevails. So the court examines both provisions and awards the higher of the two punishments. For example, Section 376 of IPC prescribe rigorous imprisonment of not less than 20 years or life imprisonment, and Section 4 of POCSO may prescribe a minimum of 20 years extendable to life imprisonment. So Supreme Court clarified that in such cases, both the laws can be invoked during trial, but the sentence is awarded under the statute that imposes the stricter punishment to ensure maximum justice. Now let's see what is POCSO Act. So the Protection of Children from Sexual Offences Act 2012 is a comprehensive law enacted by the Indian Parliament to safeguard children from sexual offences, individuals below 18 years of age. Now let's see the second judgment, Digital Access and Right to Life and Liberty Judgment. So, can access to the internet be a fundamental right? In the landmark judgment dated 30 April 2025, the Supreme Court held that digital access is now an intrinsic part of the right to life and liberty under Article 21 of the Constitution. So, this case came up while hearing petitions involving acid attack survivors and people with disabilities, where access to digital technology was a key barrier to education, healthcare, and employment. So, the court said that in today's digital age, denying someone access to online services is equivalent to denying them basic life opportunities. So, digital access isn't a luxury, it's a lifeline, and it affects access to justice, education, health, and even government welfare schemes. So, the ruling strengthens the interpretation of Article 21, pushing India closer to a digitally inclusive society. So, the court emphasized that digital procedures like KYC, that is, Know Your Customer Services, must be accessible to all citizens, including those with visual impairments and facial disfigurements. So, recognizing challenges faced by individuals unable to perform tasks like blinking of eyes or taking selfies, the court directed the implementation of alternative identification methods in the KYC process. The court also ordered the Reserve Bank of India to revise its KYC guidelines to accommodate the needs of persons with disabilities, ensuring that digital financial services are inclusive. And at last, I have given some probable MCQs from examination point of view from these two judgments. So that's all. Thank you.